Hi everyone, Stefano Molea, partner at the law office of David P. Shapiro and San Diego criminal defense lawyer. Wanted to follow up on some additional frequently asked question answers that we get from clients and potential clients. I answered about 3 during the last video, and I'll tackle a few more today. So, getting right into it, as a complaining witness or victim, do I make the decision about whether or not charges are filed? The answer to that is no. After a report is filed, and after law enforcement becomes involved and conducts an investigation, that report gets forwarded to the prosecuting agency, and that prosecutor who's reviewing the case and the evidence will make the ultimate decision. Now, of course, in a practical sense, if a prosecutor is reviewing a case and tries to make contact with the alleged victim, and that alleged victim expresses that he or she does not want charges to be filed and that he or she may not be willing to participate, that is going to be something that the prosecutor may consider. Now, sometimes a prosecutor will look at the reports, never reach out to an alleged victim or complaining witness, and make a decision that way. So it sort of depends, but ultimately the question that the prosecutor has to answer is, can he or she prove each and every element of the alleged crime beyond a reasonable doubt? And at the time of the filing, is there a good faith belief that he or she could do that? And of course, again, the victims or the alleged victims' participation is important, but not critical. For instance, there could be occasions where there is an independent witness or some independent way to prove what it is that the prosecutor is setting out to prove. So an important factor, not the ultimate deciding factor. Now, a quick note that's very important about this is sometimes when there are 2 people in a relationship, for instance, and one of those people is accused of a crime, he or she may try to tell the alleged victim, hey, if the cops call you, don't answer, or don't do this, or don't respond, or don't go to court. That is a very big problem. That is a crime. It is dissuading a witness, and it is a strike felony. And we always tell sort of the tale of the client who was in custody for a very short time on a simple misdemeanor type of case. And during his stay at the detention facility, he decided to make some phone calls to the alleged victim that were, of course, recorded, because all jail calls, unless they're to an attorney, are going to be recorded. And during those calls, this individual was essentially telling the alleged victim, don't go to court, don't answer the door, here's what you need to do to avoid getting served for the hearing, don't tell him this, don't tell him that. So he was in custody on a simple misdemeanor, and he ended up being charged with 3 strike felonies. So it is very important that if you are either charged with a crime or you might be charged with a crime, that you don't reach out to anybody who could be a witness or a complaining witness and try to influence what they do. You simply should not. And in fact, the golden rule is don't talk about the case with anybody once you think you might be, of course, investigated for an alleged crime. So that's just an important note. You also hear a lot of people sort of referring to the same thing in different ways. Sometimes the person who is the alleged victim is referred to as an alleged victim or complaining witness. Now, in a technical sense, sort of my position is you're not a victim unless the person pleads guilty or the person is convicted in some way. And that's just in a technical sense, right? But just in terms of how the person who is going to be the main witness and who is supposedly the victim of the crime, it has different ways in which they're referred. Moving on to the next question, can I get a copy of the police report that's been filed? So if there's a police report and arrest report dealing with an alleged crime, you can't just go down to the police station and ask for a copy. Sometimes if you're an alleged victim or complaining witness, you can get a redacted copy that will have some information, but it won't be the full arrest report, it won't be the full report. If you are the suspect or the potential defendant, you can't just go down to the police station and get a copy of it. The only way that as a defendant you get a copy is if criminal charges are filed, and then you're entitled to everything the reports and everything else as part of the discovery process. But otherwise, you can't just walk down and get a copy from the police station. Now, the exception to that is if there's some sort of civil action, like a restraining order or a civil lawsuit, and there's sort of the subpoena process that's followed, then theoretically, the police reports could be obtained outside of the criminal process. But that's really only the only other way in which the reports can get obtained. So that concludes sort of the follow-up questions of the frequently most asked questions from clients and potential new clients. Anything else that I can answer, feel free to contact us, 619-295-3555. Thanks.